Yes.
Let's get this. All right, good afternoon, Mr. Weiner.
Hey, Judge, how are you?
Doing fine.
Well, you got it.
I get it, Judge. I'm awake.
I'm going to try this again, Mr. Weiner. Still not right. I'm not going to try it again. Let's just call it a case. Who do you want, Mr. Weiner?
Let's do Jeffrey Fir.
All right, Mr. Fir, CR 2078. Fir is set for docket call.
That's right, Judge. You'll probably recall our announcement from a month ago. We're kind of at a standstill. I spoke with the DA's office. They still don't have the newer cases for Mr. Fir that have been are supposed to be filed that have greater ranges of punishment. So I hate to say we need to punt, but I think that's where we're at. He hasn't retained counsel on his new cases. Last time I asked the court to consider appointing him a lawyer, and the court said just wanted to kind of wait and see if the DA's office got the case. So I'd at least mention that to you and leave it up to your discretion, Judge.
Am I safe to assume that the plea negotiations on this case have stalled because of the new cases?
I think that's just illogical. I mean, it doesn't make any sense, in my opinion, to resolve these. He's going to have bigger charges coming down the pipes. We don't know what they look like, respectfully.
Tell me if you would be opposed to this. I set him on the jury trial docket, and we rock along and we go towards his trial. If those cases never come, then he's not delayed in getting his right to a jury trial. If those cases do come, then I allow him to consider plea negotiations on the other charges.
I think that's very reasonable, Judge.
Okay. All right, State, do you have any opposition?
No, Your Honor, just for the record, it appears that he was arrested on those new charges back in September, and we still don't have cases submitted on them. So I think this is, we waited long enough. I think that this is a good resolution.
Okay. Ms. Heisel, do you have any reason to believe that those cases aren't coming, or you just don't have them yet?
We just don't have them yet, Judge. I have no information one way or the other on those cases.
Okay.
There are, I believe, 5 new charges.
All right, so we'll do this. We'll go ahead and set Mr. Fir then for jury selection on February 28th, and that'll just start him on that jury selection list. And so his case obviously will not be tried on the 28th, and we'll just put him in there until he works his way up to the top. Like I said, if those new charges come in and they end up on the docket and you don't want to resolve it by plea agreement, then the court will entertain that.
Thank you, Judge.
All right, thank you, Mr. Weiner. Kelsey Tippy, if you'll make your way to the podium, please. This is CR 18-143 and CR 18-144.
Yes, Your Honor.
Good.
Sorry, he was bench warranted to Van Zandt County. These cases have been outstanding for quite some time. He had some business in Lubbock to tend to, and then was transferred to TDC. So I actually haven't had the chance to talk to him in a little over a year and a half. And so what I'd like to do is whatever mechanism we need to keep him in Van Zandt County so I can come talk to him and have a thorough discussion about the state's offer and the evidence, because obviously we haven't been able to do that for quite some time.
Do you think, Mr. Weiner, if I gave you 2 weeks, because I think I bench warranted Mr. Tippy back because I thought that there was an agreement. I thought Ms. Curry had indicated that you and she had reached an agreement on his case. Otherwise, I would have left him in TDC until his case came up for trial. So I'd be willing to reset for 2 weeks. Do you think that'd give you enough time to come meet with him and decide whether or not he's going to take a deal?
I don't know that we'll actually be able to execute the plea bargain in 2 weeks, but I think we'll be able to know whether or not we're going to be able to do that. Does that make sense?
Yes, but if there is no, like I said, the only reason I brought him back is because I was given the impression that there was an agreement between you and the state on that. So if there's, in 2 weeks, if there's no agreement, then I'm not going to hold him here. I'll just send him to TDC. We'll put him on the jury selection list and he can sit down there on his sentence without us having to pay for him.
Okay, and then would he basically be benched back again once he's up for trial?
Right.
Okay, that makes sense.
Are you available on the 22nd?
Yes, Your Honor. I'm already planning on being here, so that'll be fine.
Okay, well, let's try that then. So we'll reset Mr. Tippy then for a status on 2/22. That'll be at 1:30.
That's all I have, Judge. May I be excused?
Yes, sir. Thank you. I appreciate you being there today.
Thank you, Judge.
Just until 2/22. Mr. Stevens, did Ms. Abraham already tell you that Ms. Keels did appear? And I've got her here in the courthouse. She's sitting in the hallway.
Yes, sir. I'll be over when I finish here.
Okay, yeah, I just want to make sure. It's pretty confident they told you, but. All right, who do you want to call first? We got Dubose, Aguado, and Elder, and Rhoden.
Yes, sir. Let's do Mr. Elder.
All right, Raymond, Reese, Elder, CR 21-112. And, you know, I had some question about when the warrants that Mr. Elder got arrested on. I think, Mr. Stevens, you had the same concern. Did you investigate that? And is Mr. Elder in jail on new charges, or is it the old charges and new indictments, or what?
It's my understanding there's been new case. As soon as he made bond, it's my understanding within a few days, new cases were filed against him. I don't believe they were the original cases. I think they're new ones. I do not think they've been indicted. I have no information on the new cases because it's just happened a few weeks ago.
And so on this case, CR 21-112, remind me, did Mr. Elder make bond in this case, correct?
Yes, sir, he did. And there were maybe 5 other cases that were not actually filed that he was given PR bonds on those, if I'm not mistaken. Yes, sir. I think he said $40,000 bond on the indicted case and PR'd him on the other 5 charges, I believe is what it was.
So what he's incarcerated for today is not this case. He's on bond in this case still, is that right?
I'm not sure. I don't know if his bonds went off the bond or not. I don't know. I have not inquired.
It's been a while. I'm not sure if I have signed any type of release of surety or surrender of principal. State, hop in if you know.
Judge, I'm aware that the Texas Department of Public Safety filed a new case against him, is what he's currently incarcerated on. We do not have any records as to whether his bond company went off on the case that he made bond when we had a bond hearing a month ago, whatever time frame that was ago. We don't know if they have gone off his bond, surrendered, or otherwise. I don't have any records as to this charge, 112. There's these brand new cases that the Texas Department of Public Safety has filed against him, which is why he's currently arrested. And that happened less than a month ago.
Judge, I believe, if I'm not mistaken, my client tells me that he's still on bond for the cases that he got out on here a few weeks ago. He's just being held on the new charges.
I don't have it. I don't have it in the
Yeah, and that appears to be the case. It does look like the last activity in the clerk's case is he posted a $50,000 bond on this case. So, okay, I just wanted to have some clarity on that. So, okay, so with regards to CR 21-112, we're set for pretrial. Are there any contested pretrial matters that you're aware of, Mr. Stevens?
Not that I'm aware of, Your Honor. I'm going to ask for another pretrial date because of the massive amount of discovery in this case, and with these new cases that just got filed, I'm trying to see if I can't wrap everything up at one time, but I just need a little more time, Judge, because of the complexity of the case, and there's probably 8 or 10 videos that I have. So that's kind of where I stand, Judge.
State would be unopposed to that, Your Honor.
Okay. All right. How much time, Mr. Stevens?
If you could give me another 30 days, Judge.
Okay. All right. Court will set Mr. Elder then for pretrial on March 8th. That'll be at 1:30 if Mr. Elder's in jail. It'll be at 9 a.m. if he makes bail on his present charges.
Yes, sir.
And Mr. Stevens, obviously, if Mr. Elder's not going to be able to make bond on the other charges, with the knowledge that he's on bond right now, if there's a motion to go off bond by the bondsman or whatever, so that Mr. Elder, gains credit for any time that he's spending in jail, just let me know.
We're going to have that conversation, Judge.
All right. Thank you, Mr. Elder. We'll see you back on March 8th.
Yes.
Who do you want next, Mr. Stevens?
Trevor Rhoden.
Trevor Rhoden, CR 21-240. Show that we are set for docket call today and hearing on motion to reduce bail.
Yes, sir, that is correct.
Let's go ahead and talk about the docket call.
All right, sir.
I'm assuming that since there's a motion seeking bail reduction, that there's no agreement as to a resolution.
No, Judge, we have not been able to reach an agreement at this time.
Okay. And do you feel that you or the defendant in the state are pretty far apart?
I don't know for sure, Judge. I believe that we might could work something out. I need to just sit down and talk with the prosecutor on the case.
And what is
willing to do certain things, and I'm not sure if the state's willing to do it, but there is hope that we can resolve it. Yes, sir.
What is the offer right now from the state?
The offer right now is 12 months state jail and a $2,500 fine.
So if we pass docket call today, your client understands that I may not allow him to enter into that plea agreement or any other plea agreement after.
Yes.
Okay. All right. Court will set Mr. Rhoden then for jury selection beginning February 28th. And if you're in custody, Mr. Rhoden, then we'll bring the notices to you. If you make bail on your case, then you'll need to appear at the courthouse at 8:30 in the morning on February 28th. You won't go to trial that day, but you'll get set for another court date, and my staff will have that information for you. So, Mr. Stevens, with regards to your motion to reduce bail, do you want to call your client for that limited
Yes,
purpose?
yes, sir, I do.
All right, Mr. Rhoden, if you will, raise your right hand, sir. I'm going to place you under oath. Mr. Rhoden, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So,
Yes.
all right, you may put your hand down. Speak up loudly and clearly so I can hear you and so my court reporter can take down an accurate record. Go ahead, Mr. Stevens.
Thank you, Your Honor. Please state your name for the record.
Trevor Ashley Grossen,
Trevor, how long have you been in jail?
since October 7th last year, 4 months.
Okay, and obviously you haven't been able to post this bond that's set
Correct.
out at $20,000.
Correct.
Okay. Do you have any cash on hand to apply toward the bond? Okay. Do you have any property you could sell upon a mortgage to apply toward the bond?
No.
Okay. However, you were working when you got arrested, correct?
Yes.
Okay. And you tell me that if you get out, you're going to live with your sister. Is that correct?
Yes.
And how about work? What can you do for work if you get out?
I have worked with my brother-in-law.
And what kind of work does he do?
Well, he does real estate. He operates drones to map for real estate.
Okay. And have you worked for him before?
Yes.
Okay. So this wouldn't be something new.
No, it's nothing new.
Okay. And would you live, where would you say you live with your sister? Where does she live?
At this time, I would stay with my sister. Yes.
Okay. Is that here in the county?
Yes.
Okay. And would you have transportation to get to and from the courthouse?
Yes.
Okay. Are you asking the judge to reduce his bond to about $5,000?
Yes, sir.
If he were to do that, is that an amount of money you think that your family would be able to raise to post the bond to get you out of here?
Yes, sir.
And if he does that, can you assure the judge that you'll make each and every court appearance?
Yes, sir.
Pass the witness, Your Honor.
Hey,
State has no questions, Your Honor.
all right. Anything further, Mr. Stevens?
No, Your Honor, that's all I'd have.
Anything further, Mr. Woodward?
No, Your Honor.
All right. Is there any opposition by the state? Say you in agreement, disagreement?
State's going to take no position, Judge. We trust your judgment on this.
Okay. All right. Based on the evidence presented to the court, the only evidence I have is that Mr. Rhoden has been in custody since October 7th, 2021, and that he's been unable to make bail. His testimony is he does not have the financial ability to make that, but that he could make a $5,000 bond. The court doesn't find any other bail factor to be an issue here, so the court will grant the defense's request and will set bail at $5,000. And Mr. Stevens, did you provide an order to the court?
Judge, I should have. It should be with the filing. If not, I do have one that I'll bring by when I get through here.
Yeah, I think I found it right here.
Okay, great.
All right, I'll get that signed and sent out to the jail.
All right. Thank you, Your Honor.
Yes. If Mr. Rhoden doesn't have conditions of pretrial release already signed, he'll need to execute those. So we're going to write that on the order. All right. Are you ready on Dakota Dubose?
Yes, sir, I am.
Dakota Lynn Dubose, CR 21-212. All right, Mr. Dubose is set for docket call today.
Yes, sir, it is.
Any announcements?
We have not been able to reach an agreement, Your Honor. I think the state's last offer was 10 TDC.
All right, and so Mr. Dubose, you understand that the range of punishment for a second-degree felony offense of sexual assault of a child carries a range of punishment with a minimum 2-year range to a maximum 20-year range. Do you understand that?
Yes, sir.
And you understand that the state is offering 10 years by way of a plea bargain, and failure to accept that or a counteroffer means that I'm going to set you for a jury trial or a bench trial, however you decide, and the court's not going to allow you to enter into that same plea agreement later. You understand that? You don't know? You don't understand that?
No. Judge,
Yes, sir.
put this on another docket call, just like a week or two out from now.
State, do you have any objection?
No, Your Honor, I was literally just typing Mr. Stevens an email with some proposals from the state. So I think that would be good for me and him to talk, as well as him to talk with his client.
Mr. Stevens, I have February 22nd and yeah, I've got February 22nd. Are you available that day?
No, sir. I showed to be here on the 24th. I don't know if that's a bad day for the court, but I'm in Kaufman the 22nd, but I'm showed here in the afternoon.
You show to be here in the afternoon on the 22nd?
Your court in the afternoon. No, sir, on the 24th. I'm sorry.
Okay.
I showed to be in your court on the 24th that afternoon.
Yeah, 24th is evidentiary day, but I don't mind setting this one for a final docket call on evidentiary. So let's set it 2/24 at 1:30.
Judge, will that be here or at the courthouse?
At the courthouse.
Okay, gotcha.
Evidentiary day, everyone comes over because we're supposed to be having evidentiary hearings.
That's what I thought. I was just trying to verify. All right, thank you, Judge.
You're welcome.
Could you be here for just a second so I can talk to you after I get it? Hi, Judge. I have one more.
Mr. Aguado?
Yes, sir.
All right, is he there in the courtroom?
He is here, Judge. He's coming up to the podium now, and he's not in a position to do anything court-wise, Judge.
Sure, no, I understand.
I think he's on the list to be sent off.
All right, this is cause number CR 21-317, State versus Joseph Dan Aguado. Mr. Aguado has been deemed incompetent by evaluation, and I believe he is waiting entry into one of the state hospital programs. So we're just going to set Mr. Aguado for status. Ms. Tabraham and I have been discussing whether or not we're going to be able to maybe get some type of intervention while he's in the jail with maybe some mental health medications and things of that nature that maybe help him not deteriorate while he's in custody or move towards restoration. So we don't know if that's going to work, but we're going to give that a try. Mr. Aguado, how are you today, sir?
I'm good.
You're good. You all right? All right.
Yeah.
Well, Mr. Aguado, I'm going to set you for another court hearing soon, and me and Mr. Stevens we're going to keep on talking about your case. Okay. Do you have any questions?
No.
No? Okay. All right. So I'm going to set this. I don't want to set it every 30 days, Mr. Stevens.
Yes, sir.
Our history is that we know it's going to take quite some time for a bed to become available. And we're concerned that with his alleged offense, that it's going to require placement at certain campuses in the mental health hospital,
Yes,
state
sir.
hospital. So maybe even longer than others. So, but I do want to set him, let's set him in April just for a status. Are you available in April, maybe I set you for April 12th. I set you earlier today for that.
April 12th, good, Judge.
Let's do that. Let's set Mr. Aguado for April 12th, and that'll just be a status on his competency restoration.
Yes, sir.
And any information that Ms. Tabraham finds out, we'll funnel to you regarding whether or not somebody from our local mental health authority can come in, maybe have a doctor come in and prescribe some mental health medications to get him on. Do you know, Mr. Stevens, if he's on mental health medications at this time?
I don't think he is, Judge. I spoke with his grandmother a couple of weeks ago, and he's been off meds for quite some time.
Okay, so we'll look at seeing if we can't get that going in custody.
Okay, thank you, Judge.
Thank you, Mr. Aguado.
Okay.
Mr. Adams will be just a minute. Ms. Grisham had to step out to get something, so she'll be right back.
That's fine.
Mr. T? Yes, ma'am. Okay, thank you.
I'll try.
All right, Mr. Adams, who do you have with you?
This is Colin T, Judge.
Right, this is cause number CR 21-191, State versus Colin Gary T, set for a docket call today.
Yes, Your Honor. On behalf of Mr. T, I don't have any issues to bring up today. I would advise the court that I haven't had any plea negotiations with the state yet, but I think that we can get this worked out. If the judge, if you would give us another docket call setting, I think we'll have a plea agreement worked out by the time we would come back from that. He's got going on 12 months behind him, and we're a motivated buyer.
All right, let me see. Got you coming back on, I can bring you back soon, like 2 weeks. I don't know if you're available on the 22nd. Is that enough time?
I can come back on the 22nd.
Okay, let's do that.
Sure.
All right, Mr. Teague, we'll set you then for another docket call 2:22 in the afternoon. And if there's a plea agreement that can be struck, then perhaps we can get that done that day.
Yes, sir. Your Honor.
Yes, ma'am.
While Mr. Adams visits with his other clients, we do have Jesse Henry in the room for Mr. Ashmore.
Okay, yeah, Mr. Craddock's gonna be a Zoom for Mr. Ashmore, so I can go ahead and bring him in.
Thank you. Come on, sir.
Mr. Craddock, this is Jesse Wagner Henry, CR 20168, CR 20341, and you're standing in for Mr. Ashmore today, is that correct?
Yes, that's correct, Your Honor. He was unable to get free this afternoon, unfortunately.
And Mr. Craddock, do you know if Mr. Ashmore has gone over the indictment with Mr. Henry? I showed him to be set today on arraignment on 2 charges. 1, a 3rd-degree felony offense of continuous violence against the family, and also a 3rd-degree bail jumping and failure to appear.
As I understand, we've already waived the formal reading of the indictment, and we are looking to get a deal from or negotiate with the prosecutors and then see how we would like to move forward.
Well, I don't see a waiver of arraignment though. So let me.
Apologies if that's not the case. That was my initial briefing. I may have gotten something wrong there.
I'll tell you what I'm gonna do. I'm gonna go ahead and arraign him today. So I'm gonna share the indictment. I'm gonna give him a chance to read each one, and then we're gonna make sure his name is spelled correctly, make sure he understands what he's charged with. So, Mr. Henry, can you see that?
Yes, I do.
All right. Can you read? Read right?
Yeah, I can read you.
Okay, good. So I'm just gonna, you tell me when you're ready for me to scroll down, okay? And this is in cause number CR 20168.
Go ahead. It's all hearsay, but yeah, I've read it before. And she's not family of mine either.
You've seen everything?
I have, I've seen it all. This is all. This is funny.
So what I want you to do is I don't want you to say anything. I just want you to read it and then tell me when you've read everything. And then I'll ask the questions and then you'll give the answers.
Your Honor, I've read it all.
Okay, is your name spelled correctly in this indictment?
That's correct.
All right. And do you understand that you've been charged with a 3rd-degree felony offense of continuous violence against the family?
Sure, but that's not gonna hold water.
I'm sorry, do you understand that that's what you've been charged with? Whether you agree with it or not is irrelevant. What is relevant is, do you understand that you have been formally indicted by the Van Zandt County Grand Jury with a 3rd-degree felony? Do you understand that?
Speed trial. That's right.
So you don't understand?
I understand it.
Do I need to do a mental evaluation on you, Mr. Henry?
This is crazy. Sir, I'm an honorable vet, and I've been under attack.
I understand. Do I need to do a mental evaluation on you, Mr. Henry?
No, you don't. It's just that I'm locked up. I'm losing all my, everything out there right now is under attack. No, sir. No, sir. It's a part of the process, which is showing you the document. This is.
Do you understand that that's what you've been charged with?
Yes, I do.
All right. I need to explain to you that the range of punishment for this kind of charge is confinement in the Texas Department of Criminal Justice for not less than 2 years or more than 10 years. That's the full range of punishment. Do you understand that?
Yes.
Okay. And Mr. Craddock, how would your client like to enter his plea?
Enter a plea of not guilty at this time, Your Honor.
Does he waive the formal reading of the indictment into the record at this time?
Yes, Your Honor.
Okay, now I'm going to go over and I'm going to find the next case, and we're going to do the same thing. Mr. Henry, tell me when you're ready for me to scroll down so you can read this document.
Go ahead.
Is your name spelled correctly in this indictment?
Yes, it is.
You've been charged with a third-degree felony offense of bail jumping and failure to appear on felony. That carries the same range of punishment as the other charge, minimum 2 years to a maximum 10 years in prison. Mr. Craddock, does your client waive the formal reading of the indictment at this time?
Yes, Your Honor.
And how would you like to enter his plea?
Not guilty, Your Honor.
All right, court will find that Mr. Henry has waived the formal requirements of arraignment. The court will enter his plea of not guilty into the record and will set each case for pretrial hearing. And Mr. Craddock, let's see, we set Mr. Ashmore this morning for the 8th. So unless there's any objection, I would set Mr. Henry for pretrial hearing also on the 8th.
No objection, Your Honor.
All right, March 8th in each case at 1:30. Mr. Henry, if you make bail in each case, then your court hearings become at 9 a.m. in the courthouse. All right, you're free to go, Mr. Henry.
Mr. McCaslin, why don't you step going back up, sir?
All right, Mr. Adams, who do we have?
All right, this is Roger McCaslin.
All right, this is CR 21-362, State versus Roger Douglas McCaslin, set for pretrial.
Yes, Your Honor. On behalf of Mr. McCaslin, I don't have any pretrial issues to bring up at this time. However, or except to point out or to bring the court's attention to my lack of the, I do not yet have the video evidence in this case. I assume it exists. There is an evidence inventory that is amongst the documents that have been provided in the discovery materials up to this point. That document indicates that there is body cam footage from a handful of officers, 3 or 4 officers, and that there are video recorded statements from Mr. McCaslin and one of the co-defendants. I don't have those yet, so I need to acquire them from the DA's office. I anticipate that this case, there's a good chance this case would go to trial, and so I would like to ask for another pretrial setting so that I can look at that video footage to see if there's anything that I need to bring up or address with a pretrial motion that is out of the ordinary from the typical pretrial motions that I ordinarily file.
All right, court will grant your request. I will set an additional pretrial. We will set that. Remind me, you are available March 8th. Is that correct?
March 8th, Your Honor, I am set for a jury trial in Smith County that day, and that's a case that I anticipate will actually go to trial that day.
All right, what about April 12th?
April 12th, I'm available, Your Honor, that's fine.
All right, we'll set Mr. McCaslin then for pretrial on April 12th.
And we will make sure that whatever discovery is outstanding is made as soon as possible. And we will contact Mr. Adams to make sure that he is aware.
Thank you, Mr. Woodwhite. All right, we'll see Mr. McCaslin back on April 12th. All right.
Just have a seat, sir. Yeah, don't do that. Your Honor, can we have just a few minutes to get some more folks up here?
You're in charge.
Appreciate it. Thank you, sir.
Mr. Adams, you ready?
Your Honor, I have, this is Adam Joslyn.
All right, this is cause number CR 21329, State versus Adam Chad Joslyn, set for pretrial.
Good afternoon, Your Honor. I don't have any pretrial issues to take up with the court right now. However, on Friday, I have scheduled a telephone conference with a woman named Kim Hart, who might be someone that I might want to use as a testifying expert witness in this case in the event that we have to go to trial. I won't know that until she and I have a more extensive telephone conversation than we've had so far. She's in Ohio, so I can't go to her. She can't come to me. So we're going to talk on the telephone Friday about Mr. Joslyn's case and my thoughts about that and so on and so forth. So long story short, I'm asking the court to reset Mr. Joslyn for a pretrial hearing to allow me to do a couple of lawyerly things that I need to do before determining which way we're going to go. We do have a plea offer from the state. I anticipate that I'll be badgering them about that in the meantime, but we'll see how that works out.
Your potential expert, is that a privately retained, or are you going to be coming to the court for?
It would require me asking the county to pay the freight for it.
You're just going to begin that conversation on Friday.
That's right. I don't want to pull the trigger on filing any kind of motion and asking for money until I've felt her out and she can, or not. That's a bad way to put it, but
You said it, not me.
Right. For her and I to discuss the case and figure out if that would be an appropriate thing to do.
All right, court will reset Mr. Joslyn then for an additional pretrial. We'll set that. When do you want that set, Mr. Adams?
Last day was what? April.
I'm sorry.
April 12th.
April 12th is the first setting in April past March 8th and 10th, which you said you think would be in trial.
Right. I do not think I'll be available that week in March, so I would ask for April the 12th then.
Court will set Mr. Joslyn then for pretrial again on April 12th. Is this Mr. Smith?
Yes, Your Honor, it is.
All right, cause number CR 21392, State versus Brent Lee Smith. Pretrial hearing.
On behalf of Mr. Smith, Your Honor, I don't have any pretrial issues to bring up today. I would excuse me, announce to the court that I still need to review some video evidence in this case that the district attorney's office cannot release to me. I have to go to their office to look at that. This is I anticipate that this case is going to have to be tried. We have a plea offer from the district attorney's office. Mr. Smith and I have talked about that plea offer. I've talked with Mr. Smith about, without getting into details, the best plea offer that I think can be had in this matter. After those conversations, Mr. Smith has indicated to me that he would rather proceed to trial And so I have a good faith belief that that's what we're going to have to do with his case. And so I guess if we could set him for either a docket call, well, a docket call might be the appropriate thing to do.
Okay. All right, we'll set Mr. Smith then for our docket call on April 12th at 1:30.
Thank you, Your Honor.
You're welcome, sir. Is this Mr. Gurley?
It is, Your Honor.
All right, this is CR 21-384, State versus Jeffrey Lance Gurley, separate pretrial.
Yes, Your Honor. On behalf of Mr. Gurley, I don't have any pretrial issues to bring up at this time. I have had some productive conversations with Ms. Heisel in this case, I think. However, after having those conversations, I believe there are some pretrial, some motions that I need to file that I haven't filed yet. I wanted to wait until after visiting with Ms. Heisel about some issues before filing those motions. After visiting with Ms. Heisel about those issues, she and I both think it would be prudent for me to go ahead and file the pretrial motions that I need to file that are not just your run-of-the-mill motion to eliminate or motion to shuffle, but things that that the court would need to take up on the record, I guess. And then in the meantime, Ms. Heisel and I are going to continue talking about some other issues in Mr. Gurley's case with the possibility maybe that we can avoid a trial and arrive at a negotiated settlement. That's not certain right now, but that's where we're at. And so I guess what I'm asking for right now is for the court to set us for a pretrial hearing so that I can get my motions off.
State, any opposition?
No, Your Honor. And in fact, the state is going to request if we could, I believe Mr. Adams is setting all his cases for April. There is the possibility of further charges coming as well. Ms. Curry and I have a meeting with the Van County Sheriff's Office set up to talk about the status of those. And so there are multiple moving parts in this still. And so I think April would be an appropriate time for us to readdress that.
Okay. All right, then the court will set Mr. Gurley for an additional pretrial on April 12th.
Yeah, we're just acknowledging. Your Honor, I think that concludes everything that I had on the docket for the afternoon. May I be excused?
You may be excused, yes, sir.
Okay, thank you, Your Honor.
All right, and for the record, the case is resetting the following cases, wherein Mr. Sanders is the attorney. Mr. Sanders is in trial in Smith County. So Donald Ellis, Justin Harrell, Christopher Laney, Landon Musgrave, Terry Vance, all of those cases are going to be continued until Thursday of this week. Whatever they're set for today is what they'll be set for on Thursday. Deputy Police, do we have anyone else that's ready?
Your Honor, Mr. Schmidt should be wrapping up with his final client, and once he's done, we're already getting the rest of his clients in the room, and we should be able to knock him out.
All right, I'll stand by and let me know when you're ready.
Thank you, sir.
Your Honor, I was wondering if it'd be okay if I could be excused at this time.
Yes, Mr. Craddock, you're excused. Thank you, sir.
Thank you.
All right.
Hey, Your Honor, I'm ready to
Ms. Keels, you'll need to take your hat off. All right, Ms. Keels, if you'll make your way to the podium. This is cause number CR 21330, State versus Heather Lynn Keels, and we're set for a pretrial, Mr. Stevens.
Judge, I have no formal pretrial matters. However, I'm lacking the lab report. But I don't have, from reading all the offensive reports, I'm not going to have any pretrial issues.
Ms. Heisel or Mr. Woodwhite, were you able to hear Mr. Stevens? He says he's lacking a lab report in discovery.
Lab report is off.
Yes, Your Honor. That case is assigned to Mr. Woodwike. I'm gonna let him check on that because our system won't let us both be in it at the same time.
Notice of appearance. Yeah, that already. Where we, what date will we be setting you out? So other cases.
I got some dates in March, and I got some February.
I'll be looking to do March 8th if you're available.
I am here. Yes, sir.
Yeah, you go ahead.
Judge, the button was not pushed. It has now been pushed. Mr. Stevens should have the lab report in his online discovery.
Okay. And if an offer is going to be made, will it be made to Mr. Stevens? So he can.
Yes, 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 Judge.
Okay. All right, Ms. Keels, I called your case at 9 o'clock and you weren't here. And so I wrote on my docket, issue arrest warrant for Ms. Keels. Why were you not here at 9 o'clock? Rely on other people to do what? Well, it's important, and I understand you have to rely on other people, but it's important that you be here when you're supposed to be here. Because Mr. Stevens is ordered to be here, he's going to be here. And the only way he's going to help you work on your case is if you're here. If he comes here, I'm not going to make him sit and wait on you. When you do get here, just like today, you're not making any progress because you're not here at the right time, right? So make sure that you're here at 9 o'clock or whenever you're ordered to be here. I'm going to set your case for additional pretrial. Well, you said no, you have no contested.
No, sir, I really don't.
All right, so we'll set this for docket call on March 8th, and that will be at 9 o'clock. Ms. Keels, I want you to go over to the supervision office over here. Do you know where that is? I want you to go over there and make a payment on your bond supervision and attorney fees. I show you're behind over $100. Do you have any ability to make any kind of payment today? All right. Well, I want you to go check in with your pretrial release officer anyway. Okay. All right. So go over there and ask for Mr. Waddell. All right. We'll see you back on March 8th. Yes, thank you. I was having to read your body language and I'm like, is he ready? I don't know. We're waiting on him, but your body language told me you were ready.
My body language always says ready, Judge.
That's true. That's true. Who do you want to go on first?
We can do, right now we've got, all of them are ready, but we have pleas on Amber Smith, Ryan Augustine, and Mr. Larsey, but he's going to be last. So we can do, I have a bond hearing on Mercer, but right now that's going to be announcement for the court. Not a hearing, and then Tessa Fir is a bond hearing. So you pick.
Let's do this.
Everybody but Larsey.
Well, that's the one I was going to pick. No, I'm just
Yeah,
kidding.
he's not in here.
I know. I'm looking at Ryan Augustine. All right, this is cause numbers CR 17397, CR 21276. This is State of Texas versus Ryan. Is it Augustine or Augustine?
Sting, sir.
Okay. And let's see, I see that you have an agreement in 397. What are we doing with 276? Anything?
Judge, on the newest case, I believe that's 376.
But I've got the MTR on 397. I've got the paperwork.
All right.
But I don't see.
397 will be a plea, Judge. And then the newer, that's a MTR. We're gonna plea on the MTR, and then we're gonna set the other offense for a docket call.
Okay, so it's not a resolution of both.
No, sir.
Okay. All right, so we'll go ahead and do the plea then. Mr. Augustine, if you'll raise your right hand, sir. Sir, do you swear that the testimony you give to the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Your name is Ryan Augustine, is that right?
Yes, sir.
Mr. Augustine, Mr. Richard Schmidt is your attorney. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to discuss your case with him and have all your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed and reviewed with Mr. Schmidt that you do not understand?
No, sir.
And I see that you appeared before the court on April 10th of 2018. You were convicted of a possession of a controlled substance in penalty group 1 less than 1 gram as a class A misdemeanor under section 1244. And it appears that the court assessed your punishment at 1 year confinement in the county jail and fined you $750. Court suspended the sentence rather, and placed you on community supervision for 18 months. Mr. Schmidt, does your client waive the formal reading of the state's motion to revoke?
We do waive, Judge.
And does he intend it to plead true to all counts?
That's correct.
And do you believe your client to be competent today?
I do.
All right, Mr. Augustine, I see that the plea agreement is that upon your plea of true, the state's recommendation is that the court revoke your community supervision, assess your punishment under section 1244B at 229 days confinement in the county jail, with you receiving 229 days credit toward your sentence for the time that you have served, and that you be ordered to pay the balance of your financial obligations, including your fine, court costs, and restitution. Is that your understanding of the plea agreement?
Yes, sir.
All right, understanding those things, Mr. Augustine, then how do you plead to counts 1 through 10 as contained in the state's motion to revoke? Are those counts true or not true?
They're true, sir.
And are you telling me that those counts are true because indeed all of the allegations in each count is true?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead true to any of these counts?
No, sir.
My court will accept the defendant's pleas of true. Mr. Schmidt, any objection to the state's evidence?
No objection, Judge, but prior to proceeding, I would note for the court that counts 1 through 10, as per the motion that I received, do not allege the allegation in CR 21276. So for the record, we're not pleading true to that offense. It is not in the state's motion that I have before me, but we have no objection to 1 through 10 as as I have it. I want to make sure that there's not an amended. I haven't received an amended, so other than that, no objection to the state's warrant.
I haven't reviewed the clerk's file, but what I have before me does not appear to be an amended at all. And in the 10 counts, I don't see any allegations of new offenses.
That should be correct, Judge. So that's
Okay.
what we'll proceed on.
All right, then based on the evidence, the court finds that Mr. Augustine has violated the terms and conditions of his community supervision. Court will, upon that finding, will follow the plea agreement, will revoke his community supervision, assess his punishment at 229 days under section 1244B in the Van Zandt County Jail. The court will award him 229 days credit towards his sentence for the time that he spent in jail. Court will order him to pay the balance of his fine, court costs, and restitution. So, Mr. Augustine, you'll be remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of that sentence in that case. With regards to CR 21276, any announcement on docket call, Mr. Schmidt?
Judge, I'd ask that that matter be set for an additional docket call on that March 8th date.
Any objection from the state?
No, Your Honor.
There being no objection, the court sets Mr. Augustine for additional docket call on March 8th at 1:30. Mr. Schmidt, do you anticipate, Mr. Augustine, just one second. Mr. Schmidt, do you anticipate Mr. Augustine may be able to post a bond now on?
It is possible in our conformant that if he does post bond, that it's written on his reset, it's either 9 or 1:30.
Great, that's what I wanted to check. Thank you, Mr. Augustine. All right, who do you want next?
Amber Smith?
Amber Jo Smith, CR 20367. Ms. Smith, raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right, may put your hand down. Ms. Smith, you appeared before the court on April 13th, 2021. You pled guilty to prohibited substance in a correctional facility. That was a third-degree felony. The court heard the evidence, deferred a finding of guilt, placed you on community supervision for 3 years, and assessed a $3,000 fine. It's been during your term of community supervision that the state of Texas has filed its motion to adjudicate and revoke your community supervision. Have you had ample time to review that motion with your attorney, Mr. Richard Schmidt?
Yes.
You've had enough time to discuss it with him and have all your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
And where you did sign, you would be telling me that that is your true and correct signature, and you only place your signature there once you are confident you knew what you were signing?
Yes, sir.
Mr. Schmidt, you believe Ms. Smith to be competent today?
I do, Judge.
You've explained to her her legal rights, and do you believe she understands them?
Yes, sir.
All right, now see here that what's proposed is that she's going to plead true to all counts in the state's motion. And the state's recommendation is that the finding of guilt be entered today, community supervision revoked, punishment assessed at 6 years confinement in the Texas Department of Criminal Justice, with that being suspended today, and her being placed on straight probation for 2 years with the balance of her financial obligations, including 180 days in jail as a condition of community supervision. Is that your understanding, Mr. Schmidt?
Judge, this is my understanding. Yes, yes, sir. They do.
All right, Ms. Smith, yours as well?
Yes, sir.
Ms. Smith, before I go any further, do you think that you're going to be successful on this second probation more so than you were on the first?
I'm sorry. I didn't.
So the plea agreement today is moving you from one kind of probation to another.
Yes, sir.
Why do you believe that you will be successful on probation?
Because I have been locked up for a very long time, and as long as I've ever been locked up, I've been away from my family, I've been away from my kids, and it's just, I I will never put them through this or myself through this again.
So if I go along with it, I'm not going to see another motion to revoke.
Absolutely not, never. And I also took like 42 classes. So,
Okay. All right. Well, I'm gonna take you at your word.
thank you.
And Ms. Smith, so at this time, I'm gonna ask you, how do you plead to the counts alleged, which are counts 1 and 2 in the state's motion? Are those counts true or not true?
True.
And are you telling me that they're true because you committed the conduct alleged in those counts?
Yes, sir.
All right, the court will accept the defendant's pleas as true. Mr. Schmidt, any objection to the state's evidence?
No objection, Judge.
State's evidence is admitted and the court does take judicial notice of Ms. Smith's judicial confession. Anything further from the state,
No, Your Honor.
from the defense?
Nothing further.
All right, based on the testimony and the evidence before the court will find that Amber Jo Smith has violated the terms and conditions of her community supervision. Court will finds that it does have sufficient evidence to convict Ms. Smith of the underlying offense. The court will follow the plea agreement in her case. The court convicts her of the third-degree felony offense of prohibited substance or item in a correctional facility. The court will assess her punishment at 6 years confinement in the Texas Department of Criminal Justice Institutional Division. The court will suspend that sentence today and place her on 2 years community supervision, order her to pay the balance of her fine, restitution, court costs, and reimbursement fees. And the court will order her to do 180 days in jail as a condition of community supervision, with her receiving credit towards that condition for the time served between May 14th, 2021 to November 9th of 2021.
Okay.
So Ms. Smith, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you go with Deputy McLeish to be fingerprinted. After that, speak with the probation officers and they'll give you more information about the next step, okay?
Okay. She's probation.
She is.
Oh,
She
okay.
is probation.
Who do you want to use?
Mr. Mercer.
All right, Douglas Keith Mercer, CR 20264. All right, and this is for bail reduction hearing. Do you want to call your client for that limited purpose?
If I might make an announcement to the court. Previously, some months ago, Mr. Mercer's bail was revoked in court by Your Honor. We were set on the jury docket. Mr. Mercer had filed a motion to terminate me, and I filed a motion for a bond reduction, et cetera. I've talked to the state. Me and Mercer, Mr. Mercer has had an opportunity to discuss the bigger picture here today. And what we would ask that the court allow us to do is to accept the state's offer and enter a plea to such on Thursday afternoon, and we will withdraw all the other motions that have been filed, if the court would entertain it.
Yeah, court would grant that request.
Okay, so if we could set it for Thursday and we'll get her done that day.
We will make sure the paperwork is ready for you, Mr. Schmidt, as soon as possible.
Thank you.
All right, court will set Mr. Mercer then to enter a plea before the court on February 10th at 1:30.
Judge, in this room right now, I have a Ms. Fir on a bond hearing. I've got Mr. Larsey. I haven't brought him up yet, but he'll be a plea when they do get everybody else out.
Go ahead and bring Ms. Fir up. This is CR 21-124, State versus Tessa Fir. This is on motion. Is this a motion seeking bail reduction?
That's correct, Judge. It is simply a bond reduction hearing. I will tell or inform the court that I've discussed with Ms. Curry bond reductions in the past and recently. Basically, we have an agreement with the DA's office with Ms. Curry for a reduction to $100,000 cash or surety bond. I recently spoke to Ms. Curry. She's sticking with that. Her bond's set at $250,000, but we've got an agreement for $100,000. We've had that for quite some time, but due to other circumstances, we didn't send that proposed order with mine and Ms. Curry's signature to the court. However, at this point in time, we're specially set in May, and we're trying to get the court or ask the court to reduce Ms. Fir's bond to a lower amount so that she can bond out and be available with me to prepare for trial, which will go forward in May. But we can proceed with bond hearing, and I can call Ms. Fir if you want to hear it.
Did you say, Mr. Schmidt, that the total was 250? Is that on one charge or two charges? I'm only showing that
Right.
I'm only showing a $200,000 bond this time.
Judge, I might have misspoke. It's 200,000. She was arrested on one offense, but indicted on 2 counts. So they changed it, but ultimately that sounds right, 200,000. But Ms. Curry has agreed to reduce to 100,000. She signed an order, an agreed order to the same, but she can't make that, and she doesn't agree to any lower than that. So that's where we're at.
I'll let you call your client. Ms. Fir, if you'll raise your right hand. Ms. Fir, do you swear that the testimony you give to the court today in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right. Make sure you put your hand down. Make sure you speak up loudly and clearly so that I can hear you, so my court reporter can take down what you have to say, okay? Go ahead,
Yes,
Mr. Smith.
Ms. Fir, you were arrested and charged with an arson-related offense February 16, 2021, correct?
Yes, sir.
So you've been in continuous custody nearly a year on this case, correct?
Yes, sir.
At this point in the status of your case, we've announced ready for trial, and we intend to go. We have a special setting in May. You're aware of that.
Yes, sir.
And you're aware of right now, we've had issues. The court has agreed to order that you be housed in Vincent County up at a certain date so that you and I can prepare for trial. But right now, you spend the majority of your time in Henderson County. Is that correct?
Yes, sir. That's correct.
So that means you and I have limited or no ability to communicate on your case.
Yes, sir. That's correct.
In addition to that, you understand that we've negotiated with Ms. Curry at the DA's office for a bond reduction, and we have an agreed order for a reduction to $100,000, and you're aware of that, right?
Yes, sir. That's correct.
But you're also aware, or you've made me aware, that even at $100,000, you could not post that bond. Is that correct?
Yes, sir. That's correct.
So since you've been arrested, your bonds have been set at $200,000, and you've been unable to raise the money with family and friends or property in order to post that. Is that correct?
Yes, sir. That's correct.
Now, today we're asking the judge to consider a reduction to something lower than $100,000. If the judge were to agree to lower your bail amount, what is an amount that you could possibly make?
I mean, I was hoping for like 50 or 60,000.
Okay, so if it were lowered to 50,000, do you believe that you could come up with the 10% to pay a bondsman?
I have spoken with a bill bondsman that said that they would work with me at like 5% if I could get it to that.
So, and at this point, you've been in custody for right at a year, pled not guilty, and you've got, you were living in an apartment that's no longer exists. So if you were to make bond, where would you live?
I would go to my mother's house in Edgewood, and I've already been offered a job to help with things.
Okay, so you've got, if you can get out, you've got a place to live that's in this county.
Yes.
You have a potential job so you can actually earn some money.
Yes, sir.
And do you have children, minor children?
Yes, sir.
And are they in Edgewood as well?
One's in Edgewood, one's in Wells Point.
And so you'd be there. Would you have transportation back and forth to court?
Yes, I would.
And do you have any property, any assets that you could sell, any money in the bank that you could raised to make it as posted now?
No, it would be help. I would have help from family members. I have absolutely nothing at this point. I have nothing.
So you have no personal assets,
I have absolutely nothing.
and any bond amount would have to be posted by a friend of the family.
Yes, that's correct.
Are you assuring the court that in the event your bond is reduced and you are able to get out, that you will make it back and forth to all your court dates?
Oh, yes, I want this taken care of.
And ultimately, as we are right now, you should not have an additional court date except for your jury trial.
That's correct.
And you're aware of that.
Yes, sir.
You also are aware that if you were able to get out, you'd have to meet with the pretrial release officer every month.
Right, that's correct.
Regardless. Okay. I'll pass the witness, Judge.
State, any questions?
Just a few, Your Honor. Ms. Fir, you said you had a job offer if you were to get out. Where's that at?
It'd be at Edgewood at a Mexican food restaurant that I was working at. That's the first job. They said they would start me immediately.
Okay, so you've previously worked there and they would reoffer you
Yes.
employment? Okay.
Yes, ma'am. That would be a start.
Okay, and then you said you had transportation, but you also testified that you don't have any assets that you could sell, such as a car. So what transportation would you have to get you to those pretrial release appointments?
My father has recently had 3 strokes and he's not able to drive right now. So it's his truck that he said that I would be able to use to get back and forth.
Okay, so you wouldn't be relying on somebody else to get you here. You would be bringing yourself, but it would be somebody else's vehicle.
Correct, correct.
Your Honor, I have no further questions.
You have any argument, Mr. Schmidt?
Judge, I do know that we could go through the standard Bell arguments. Obviously, the court is aware and the DA's office is aware of the law on those issues. I do know that Ms. Fir right now is specially set. I do know that we're specially set because these are complex cases. And I will need to get my hands on her for her defense. I believe that if she were to post a surety bond, if the court could lower that to $50,000, then I could have access to her on the run up to preparation for trial, which I expect is going to be a significant endeavor. I do know also that, being in custody over a year on one charge is prima facie evidence that the bond as set is too high because she cannot post that bond. Otherwise, she would have already. We'd ask the court to reduce that bond to at least $50,000 to give her an opportunity to bond out and take care of some of these matters, including and most importantly, preparation for trial in May.
Thank you, Mr. Schmidt. Ms. Heisel?
Thank you, Your Honor. Your Honor, just because a defendant is unable to make bond does not mean that that bond is unreasonable. And in this case, we have 2 deceased victims. We have their families to consider in this. And because we do have that, we also do have concerns about the safety of the community if Ms. Fir is to get out. Your Honor, we may feel differently if this was set further out or not set for a trial date, but we do have a specially set trial coming in just 3 months. We have agreed to half her bond already to $100,000. And so the state is going to ask you for the victims' families and for the community at large to set the bond at $100,000 and not less than that, seeing that we are going to guarantee Ms. Fir a trial here in the next 3 months.
Mr. Schmidt, you want to respond at all?
No, Judge.
Okay. All right, the court is going to deny the request to set bail at $50,000. I will honor the agreement between the state and the criminal district attorney's office. The court will approve a bail reduction by 50% to $100,000. I'll sign that order today, Mr. Schmidt, and have that sent over to the sheriff's office.
Will do. Thanks, Judge. Yeah.
So what we say about
let Mr. Schmidt know when they have access to it. Mr. Schmidt, are you ready?
Mr. Larsey should be in here in just a second. That's all we're waiting on.
That's all we have left. Okay, and Ms. Tabraham and I were just discussing, we're going to inquire about the availability of keeping Ms. Fir in county from now,
Yes.
Until.
Sounds good. Sounds good.
So as long as we have availability, we don't have any jail standards that require us to put her in another county, we're going to try to keep her here for you.
Fantastic. Thank you.
Check the blanks.
Judge, I can tell you, Charlie. And since the state's here, we're about to, Mr. Larsey's going to plead. He's doing 8 TDC. There's some question about the credit time, so I just want to make you aware. He believes that it's missing several months. He was housed in Hunt County. I don't know one way or the other, but I do know that he's been my client for, going on close to 2 years, and he has never been out of custody. So I'm not sure there are bond issues, PR bond in one county, not on bond here, but I'm just going to make the court aware that he's prepared to move forward with the plea, but he believes that the credit time is incorrect.
Richard, if you have dates about the Hunt County time that he believes should be on there, if you could just shoot me an email. If we can get confirmation of that, I'm happy to give him credit for it.
I know you are. What I'm going to do is, if the court will entertain it, I know that once we do the plea, we can question him about those dates because he tells me, but they're unclear to me at the same time. So maybe he could clarify it for the court.
Yeah, how about we do this? How about I can put you on a breakout room and y'all can talk about it, and then once y'all get it figured out, y'all can hop back over to the main session. Do that? Okay, I'll set that up.
He's doing that.
Yes.
I'm not sure.
And Ms. Heisel, I'm going to invite Ms. Abby into that room too, so she can hear it as well.
Thank you, Judge. Mr. Larsey, can you hear me? Mr. Schmidt? Give me a thumbs up if you can hear me. There we go. Ms. Abney just called and she said she believes your accurate time credit should be 500 days. So that she's updating the judgment to give you 500 days back time.
Thank you. That sounds right.
Thank you.
And she will email that to Ms. Burns at the jail when she has it, so y'all can see a copy of the corrected judgment.
Did you say 500 even?
500 even is what she said.
Hey, Hillary, also with these two, with the plea and the 1245, you don't show any other business for Mr. Larsey in our county, do you? We should. They should take care of all of it.
Mr. Larsey had one other charge he was arrested for, which we have already declined and sent dispositions on. If you need a copy of that disposition, I can get it for you, but yeah, he's got nothing else.
Okay, that'd be good. Thank you. Partner today that he could, his wife is actually trying to have a baby. Gotcha. She's been trying to have a baby. The kids got a professional. I'm sure they should just knock this thing out. Shouldn't be that hard. That's nothing. I could have done that. Okay. My oldest daughter majored in criminal psychology. Yeah, started that way. She works at Terrell State. She evaluates one, listen to one thing, come back here, go to court.
Mr. Schmidt, are you ready on Mr. Larsey?
Yes, sir.
Did we get all the issues regarding credit time worked out?
Believe we have, Judge.
Right, and is what is appearing on my judgment. I want to know if that's correct. I'm showing 332 days.
No, Judge, it's going to be 500 even, and we are going to send a corrected judgment out to the jail so Mr. Larsey can review it and then have it sent back to the court with the rest of the paperwork.
Okay, excellent. All right, Mr. Larsey, if you'll raise your right hand, sir, I want to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Make sure you speak up loudly and clearly for me so that I can hear what you have to say and my court reporter can take down everything, okay? All right, for the record, this is cause number CR 2178 and CR 2179. It looks like that the agreement in CR 2179, which is the evading arrest or detention with the vehicle, which is a state jail felony. It's going to be a plea of guilty. It says state jail felony, but that's
enhanced.
Enhanced
To a third.
All right, there's an enhancement paragraph in the indictment.
Yes, sir.
All right, so upon a plea of guilty to the enhanced charge of evading arrest or detention with a vehicle, then the defendant will be sentenced to 8 years confinement in the Texas Department of Criminal Justice with a $2,500 fine, with the state recommending the dismissal of CR 2178 and a 1245. Restitution, fines, court costs, reimbursement fees, 500 days credit. Does that sound right, Mr. Larsey?
Yes, sir.
All right. Mr. Larsey, a state jail felony enhanced to a third-degree felony, if the allegation in the indictment is found to be true, would increase the punishment range in this case from a minimum of 2 years to a maximum of 10 years and a maximum fine of not more than $10,000. Do you understand that full range of punishment?
Yes, sir.
And you have been charged by indictment with a state jail felony offense of evading arrest or detention with a vehicle, and the state has alleged in the charging instrument, which is otherwise known as the indictment, they have alleged that you have committed a prior offense that, if found true, increases that punishment range. Do you understand that?
Yes,
Now, in this case, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with his representation of you?
yes, sir.
And are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
Mr. Schmidt, do you believe Mr. Larsey to be competent today?
I do, Judge.
You've explained to him his legal rights.
Yes, sir.
You believe he understands them.
I do.
All right, Mr. Larsey, then I'm going to ask you, how do you plead to evading arrest or detention with a vehicle?
Guilty.
And are you pleading guilty to that charge because you are guilty of committing that crime?
Yes, sir.
I'm also going to ask you with regards to the enhancement paragraph contained in the indictment. Mr. Schmidt's kindly showing you there. In that indictment, the state has alleged that on March 28th of 2012, that you were convicted of the felony offense of burglary of habitation in Hunt County, Texas, in the 196th Judicial District Court. Would that allegation contained in that enhancement paragraph, would that be true or not true? True? And are you telling me that that is true because the allegation contained there is true? You're not just telling me that so that you can get a certain plea agreement, right?
No, sir.
Okay. All right. Court will accept the defendant's plea of guilt and also his plea of true to enhancement paragraph number 1 contained in the indictment. Mr. Schmidt, is there any objection to the state's evidence?
No objection, Judge.
All right. State's evidence is admitted. Court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor, briefly, Mr. Schmidt inquired about, when Mr. Larsey was arrested, there were actually 3 charges. We are obviously taking care of 2 of them today. The third was a tampering charge that the state rejected upon intake. I have emailed Mr. Schmidt a copy of that disposition for his records. I believe the jail already has it, and Mr. Larsey's book in, book out should reflect that disposition. But just wanted it on the record that this does resolve all of his business with Van Zandt County today.
Anything further on that, Mr.
No, in fact, guys, put that on the record. That's all we have.
All right, I'm gonna take just a moment and review the evidence.
Never stop. There's 3 of them, I guess.
All right, the court's reviewed the evidence and I find sufficient evidence to convict Mr. Larsey of this offense. The court will follow the plea agreement. The court hereby convicts Daniel Scott Larsey of evading arrest or detention with a vehicle. The court finds the enhancement paragraph to be true. The court finds that the punishment range is that of a 3rd-degree felony. The court assesses his punishment pursuant to the plea agreement at 8 years confinement in the Texas Department of Criminal Justice Institutional Division. Court also assesses a fine of $2,500, $180 restitution, $85 reimbursement fees, and orders payment of court costs of $290. Court dismisses under Section 1245 CR 2178. The court awards Mr. Larsey 500 days credit towards his sentence for the time that he has spent in jail on this cause previously. Mr. Larsey, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence, and have you step over with Deputy McLeish so that she can get your fingerprint. Once you are released from TDC, sir, it's gonna be important that you contact the courthouse and talk with the court collection officer so you can start making arrangements to pay off some of these fines on a payment plan so that you don't wind up back in jail, okay?
Yes, sir.
All right, good luck to you, sir.
Go ahead, Judge. I'll be excused.
Yes, sir, you may. And then I'm gonna keep on working on that paperwork that I sent over there to you.
Sure.
I'm ready. I'm gonna try to get that to Commissioner Court next week, so I'll be hollering at you soon. They may just be that I'm gonna ask them to allow me to begin that process. Maybe not have it approved, but begin that process, get the okay for it.
Sounds good. I'm gonna be working on it tomorrow as well, so.
All right, thanks, sir. I do appreciate the help.
Yeah. I got you. All right.
And Judge, would you just have the clerks let us know if there's anything we need to come over and sign?
Yes, we'll double check it.
Okay,
Ms.
thanks,
Hassel,
Judge.
Ms. Hassel,
Yes,
I can tell you right now, there are a couple of blanks in this paperwork over here for the state.
okay. I will meet y'all at the courthouse before I head out of town.
Your Honor, is there anything else we can do for you here at the jail?
I think that we've covered everything, haven't we? And let's see, do you have a note on Miss Fir? What was the date I gave her? I don't think I wrote it down. No, it was just the writ, so we're already set for trial. That's why we don't have a date. So
Yeah, she specially said, Judge.
yeah, never mind. So, okay. All right, I believe that is a wrap. So we will be adjourned and we'll appear again on Sweet Week.
Thanks.